All right, we're here today interviewing prospective Circuit Court Judge Randy Kostrzewa, his name is Raymond Kostrzewa, but
Yes.
everybody that knows him calls him Randy.
That's correct.
So Randy, tell us why you want to be Circuit Court Judge.
Well, one of the most important factors that weighed into that decision was the fact that James M. Grace is retiring after 35 years on the bench. And that is no small bit of experience that we are losing on the bench. And I felt it was very important to our entire community that you replace a sitting judge with someone with real experience, real courtroom experience. And that I have. I've been an assistant prosecutor for almost 20 years. It'll be 20 years in November of this year. And for that time, it's almost 20 years of trial experience. I've had over 80 felony jury trials. I've handled hundreds and hundreds of cases in the very circuit courtroom I'm asking to be elected. And I felt that it was very important to fill that position with somebody that has real courtroom experience. I saw the need. I saw that I had some gifts that were given to me and that I was able to help our community. And so I felt it was important to run.
What's your legal background from the time you graduated from law school?
I graduated from law school in 1991 from the University of Detroit School of Law. While in law school, I participated in what is still called the Urban Law Clinic out of the University of Detroit, and it is basically a system where law students are able to practice law under the tutelage of a practicing lawyer or a series of practicing lawyers, and they actually handle criminal cases. And my first jury trial was in district court down in the Detroit area representing an indigent criminal client. So my first jury trial was as a criminal defense lawyer. That began my trial practice. Immediately out of law school, I practiced with a law firm in the Detroit area, large law firm in the Detroit area. At the time, they were known as Kitch, Sowerbeer, Drutchess, Wagner, and Kinney. They principally handled medical malpractice defense cases. I practiced for them for a brief period of time when in 1992, in the fall of 92, I was hired by the Muskegon County Prosecutor's Office, and that's when I began my career as an assistant prosecutor.
What's your experience been on the civil side of the bench or the family court side of the bench?
Well, you work for the prosecutor's office, so you are charged with the obligation of handling criminal cases in Muskegon. And so since 1992, I've principally handled criminal cases in Muskegon County. And that's because that's the duty of the prosecutor. I've had other opportunities to practice outside that area, but I felt it was important for me, and I had a passion to serve the public.
Some counties have what's called drug courts, in that they focus on intense attention to the particular criminal defendant that has a problem with drugs. Muskegon County doesn't have one of those yet. Should we?
I'd be in favor of a drug court, and if it took a circuit court judge to spearhead that and make sure that we were eligible and applied for any appropriate grant, I'd be happy to do that. Now, I want you to know that just because you put a label on something and call it a drug court, that doesn't necessarily mean it's going to be successful. That doesn't necessarily mean that it's anything different than what's at the disposal of a circuit court judge right now. I think that if you were really focusing on drug rehabilitation and got a grant, yes, you're going to pour some money into that, and you're going to have some more programs available to you, of which I think is a great idea. Anytime a judge has another series of options or another option in terms of the sentencing perspective, anywhere, the perspective from do nothing to this individual and to incarcerate long term. I mean, that's the opposite ends of the spectrum,
exactly.
right? Every time you put an option in front of that judge that's somewhere in between there, the judge has two things going for him. One, he's got to, or she's got to, pour themselves into the case a little bit more to explore what is the appropriate use of the resource. So you've got to invest yourself a little bit more with the more options you have to figure out which is the appropriate one to use, but it also lets you blend a sentence that's more in terms with justice. Justice for any victim that's been victimized, and justice for the defendant, which oftentimes means punishment, but also rehabilitation. I mean, there's a number of different components to an appropriate criminal sentence, and one of them is rehabilitation. And I feel it's strong that if a criminal defendant presents themselves to the court after having committed a crime and they have a heart and a mind to rehabilitate themselves, that we should give them an opportunity to do it. If a drug court is going to help that, I'm all for it.
We have a situation right now.
Can I add to that one?
Please go ahead,
Mr.
Go ahead.
I want you to know that right now the circuit court judge is a judge of general jurisdiction. They can use any sentencing options that's available to them right now. Right now, there's a lot of really good drug and alcohol rehabilitation programs in our area and in our state, and they are at the disposal of a circuit court judge right as we speak, without having put the label on them of drug court. Yeah.
Well, are you talking about services outside of Muskegon County?
I'm talking about services, some right inside Muskegon County.
Okay.
There's a pretty effective drug and alcohol rehabilitation program right on Honolulu Road. It's called Teen Challenge. Mm-hmm. It's a very effective program. It's a 1-year intensive, inpatient, you live there program. And if you make it through that, the success rate is very high. Now, it's very spiritual based. Mm-hmm. You know, I mean, you have to be open to that. But there are other ones that are not as intensive in the spiritual setting as that. But, you know, I'm aware of the Salvation Army 6-month program in Grand Rapids. I know that there's many other drug and alcohol rehabilitation programs in our area. The Chester Ray drug and alcohol rehabilitation program. I think the lights went out on us.
Yeah, they did.
So those are right now at the disposal of
Motion detector.
Yes, they're at the disposal of a circuit judge right now, without the label of drug court. Now, once you do get some money and some resources poured into another sentencing option, that would be outstanding, and I'd be in favor of it. I would support it, and I would spearhead it if given the opportunity.
Okay.
Sorry about the long-winded
Please
answer.
go ahead. We're here to listen to you, not me. We've got a situation where right now in the county jail, and I just looked at the sheriff's website, this is totally random. We've got 40 people in there for drug offenses, 17 in there for drunk driving, 7 in there for not paying child support, 6 in there for failing to register as a sex offender, 5 in there for driving with license suspended, and 2 in there for open receptacle. Does that indicate to you that there's some type of sentencing problem or some type of misuse of the jail to have all of those people in there? I realize maybe some of them should be in there, but just based on what I've told you that the stats were as of about 10 days ago, do all of them really need to be in jail?
Well, what you're doing, Mr. Crehan, is giving me very limited information. And to make a very general statement as do all those people need to be in there, having given me nothing about their criminal background, having given nothing to me about their circumstances of the commission of the crime, it is very hard to answer that question. Do they need to be there? I mean, that question of does somebody need to be there takes work. I mean, this isn't just cookie cutter justice. I mean, this takes work. I mean, you need to delve into a case and treat it like it's the most important case in the world when it's in front of you. And that means getting reports from people that have interviewed people. That means reviewing police reports if they're available to the judge. That means looking at a pre-sentence investigation report, of which takes into account the person's educational background, their criminal background, their employment background, their financial background, their just a whole different array of factors that come into play when you pass sentence on somebody. So just to say, do they need to be there, just giving me the generic name of the crime for which they're in jail, that's a tough call. Now, if you're asking me in a general sense, does somebody with an open receptacle case need to be in jail? Probably not. But having given limited, what if it's his 5th time with an open receptacle?
It's his 5th time with the 5th, so he's got to be in
Yeah, you know what I mean? I mean, it's a factor that you have to consider. And to say, yes, this person needs to be in jail, or no, that person doesn't need to be in jail based upon a label of what they're charged with. Very difficult to answer that question. So I apologize for skating around it, but it's just the way that sentences are. I mean, it takes work, and the judge has got to invest themselves in learning about the case and the people and the circumstances to make that decision.
Look, I'll give you a little more of a broad question here. I've
All right.
taken felonies and have divided them into 3 categories.
All right.
Violent felony with a victim, non-violent felony with a victim, and non-violent felony without a victim.
All right.
The last category, non-violent felony, no victim. Is it really necessary to incarcerate them anyway?
Again, what is a nonviolent felony without a victim? What do you consider a nonviolent felony without a victim?
Non-violent felony, no victim. I'll take fleeing and eluding, for example.
Now hold on a second, Matt. I'm going to tell you, fleeing and eluding is not a nonviolent felony without a victim.
Who's the victim?
If you were on that public highway and someone was fleeing the police and ran the red light, in fact, we are at the corner of 3rd and Muskegon, and I handled a case with a fleeing and eluding case. And I'm going to give you a set of circumstances, Mr. Crehan.
All right.
They passed a bad check at the bank.
Okay.
All right down there at what was National City Bank at the corner of Terrace and Lakeshore.
All right.
All right? Non-violent crime, right?
Right.
Bad check.
Right.
They were trying to get some money. Now, they happen to be crack cocaine addicts, so now we're dealing with the underlying offense of drug addiction. But they passed a bad check.
Okay.
The police were called. They fled the police. 2 of the people got out of the car and were apprehended. 1 person got in the car and fled the police right up here and was heading what would be, I guess, eastbound on 2nd Street here, and right in front of the Shell station ran the red light, fleeing the police, and struck a motorcyclist.
But there's a victim.
Well,
a motorcyclist.
but just by the grace of God, somebody else wasn't there, and just by the grace of God, somebody wasn't there on your fleeing and eluding case. So, I mean, fleeing and eluding to me is a serious felony.
But
let me answer the question. That person has a closed head injury for the rest of his life because of a fleeing eluder. Now, if given the circumstances of a case of an individual, so you have to appreciate this, Mr. Crehan, that I've seen some pretty horrendous cases coming out of fleeing and eluding cases.
Absolutely.
So I look at them as very serious.
Well, the one you just brought up has a victim. So
Yes.
that's
Well, I think, so what you're saying is just because of the name of the crime does not mean whether or not it has a victim or not.
It doesn't, and you have to look at the circumstances of that. Now, if you are presenting me with a situation where there's a fleeing and eluding, where they flee the police, refuse to stop, and no car is hit and no person is injured, I still look at that as a serious felony, with the victims being any potential driver or pedestrian that happens to step out on the street. I mean, so when you call it a victimless crime, I'm not entirely buying into that.
Let me give you another one. Let's say somebody has possession of marijuana.
Yes, sir.
And it's, I'll say, a shoebox full, enough marijuana where it's like it's not just a little bit for 1 or 2 joints.
Right.
Again, nonviolent felony.
Correct.
No victim, just possession.
Right.
Do they need to be incarcerated for that?
On a first offense, I would probably say no. Yeah, if their criminal history didn't indicate a habitual problem, I would say probably not. Probably not.
Jail, do we need a new one?
I believe we do. When I started in the prosecutor's office in 1992, we were dealing with jail overcrowding issues, and it's been an ongoing issue ever since then. So, in conjunction with jail overcrowding issues, we've also dealt with the pretty consistent deterioration of the building. The physical plant is not only not big enough, it's getting old, and a number of factors come into play when you say we need a new jail. You're not only dealing with the inmate population, of which I believe the Eighth Amendment is there for a reason. I mean, we can't put people in horrendously bad conditions. I mean, we don't lock people in the tower anymore in London where there's water dripping on their head and, rats rolling around. That's just not that's not humane treatment of people.
Exactly.
And I'm not saying our jail is that bad, but at times it's close. It's close. There's a ventilation problem in the jail. There's a problem with waste disposal. I know, and it's an issue. So the physical plant is not as up to par as it should be in terms of the treatment of the jail inmate population. But you also have to respect that generally the jail inmate population can't stay in the jail any longer than a year. A year is the maximum jail sentence. So the inmate, lucky for them, may be only exposed to a year to that. What if you're a jailer? What if you work in the county jail and you've been there 20 years or 25 years and you've been working in that facility for 25 years under those same conditions? You're breathing the same air, non-ventilated air. You're dealing with the same physical plant that's inadequate. What about the jail medical staff? They have to deal with that physical plant as well. And I just think it's time for us to get serious about what we need in Muskegon County. I think a new jail is something that we should seriously consider.
Okay, the jail in the late 80s was about 250 capacity. And then there was a lawsuit from, at the time, Sheriff Pennington sued the County Board of Commissioners, and Judge Kalenda from Kent County made a ruling that you shall have space for so many inmates. County Board came up with the idea of, okay, let's put them in the basement of the county building. It's now been expanded to approximately 400 beds. So from 250 to 400, that's a pretty good increase. Is that enough beds, new jail or not?
I would think if you're going to build a new jail, it probably should have the capacity to house around 500. If you were going to build a new jail, I mean, we're pretty consistently overcrowded, and I think the number is 375, if I'm not mistaken.
I think you're right.
In terms of the
technical capacity.
In the capacity of the jail might be 375. We're pretty consistently around 400 in the jail, sometimes higher, which precipitates early releases from jail sentences.
If you have a 500-bed jail, isn't it axiomatic that as a judge, a policeman, a prosecutor, you're almost bound to fill it up, because if you're not, you're perceived as soft on crime?
No. Here's the real crux of the issue, and this comes back to my first answer to your question. It's about experience in the courtroom. It's about having dealt with these issues for the bulk of my entire career as an assistant prosecutor. You have got to be able to make the distinction and have the discernment, the wise discernment of who needs to be in and who doesn't need to be in. Because not everybody needs to be in. It's what you posed a question to me about, do these nonviolent first-time offenders need to be in? And maybe if they need to be in, is it a shorter period of time? I mean, do you shorten the period of time that they need to be in, or use other jail diversion programs, or drug and alcohol rehabilitation program, or a tether program, or some other option in terms of sentencing to modify their behavior? But you've got to have the discernment. You've got to have the ability to distinguish who needs to be in and who doesn't need to be in, and you've got to make the right decision, the right call at the right time. It's not about filling the jail. It's about using the jail space that's available in a judicious way, a wise way. So I'm not saying, you asked me if you were going to build a new jail, is 400 beds enough? I would say if you're going to build a new jail and invest, $30 million, you probably should make it roomy. Put some classrooms in there, so that you can provide a setting for inmates to get their GED. Give them a classroom. Give them several classrooms. Make sure the medical staff has got adequate room, not just a small little corner office, but a room to really do their job and do it well. I would like to see in the jail the capacity to treat mentally ill inmates. I would like that to be a facility that has the room to do that. You and I know that a large number of the inmates that come into the jail either have a drug or alcohol program or a mental illness. You've got to be able to address those issues. So when you ask me if you build a new jail, should it be big enough? I think it should be big enough to have some room for people, but it also should be big enough to have classrooms, to have adequate medical facility to accommodate a mental health treatment area, of which I don't think we have adequate space right now. Okay. But In terms of the judge's decision, you've got, it's not about filling the jail space that you have, it's about wisely using the jail space and making the decision who needs to be in and who doesn't need to be in. And that comes from experience.
If you had a choice, it was one or the other, would you rather have 500 beds or more classrooms?
I would rather have an adequate jail that has enough bed space to accommodate what we have going on in Muskegon, and classrooms. So if you were going to say, okay, here's the budget, Mr. Kostrzewa, and you are the one that's going to make the bottom line decision, I'd say we need to have enough jail space to adequately house our prisoners, but we are going to put in that jail classrooms. We are going to put space available so that the inmates there have an opportunity, if they so desire, if they have a heart and a mind, to get their GED, to get educated. We're going to make space for that.
So you believe in rehabilitation then as well as punishment?
Absolutely. I think there's many facets to an appropriate sentence. Punishment is one of them. Rehabilitation is another.
Let's say, for instance, that you get a complex civil case that lands in your court, and you said you've had 20 years of prosecutorial experience. What's your experience with civil cases?
I'll tell you this, Mr. Crean, I'm not going to beat around the bush. When I'm faced with an issue in a criminal case that is new, what do? You
ask for help.
You study.
You study.
You learn.
Right.
You dive into it. I've studied many issues, and not just because it's a criminal case. I mean, there's criminal cases that have pretty complex medical issues. I mean, I once handled a criminal case. It was an individual shot and died many, many months later, and the issue was there a superseding, intervening cause of death in terms of his medical complications? And he had a lot of other medical complications other than being shot, other than this gunshot wound. The defense was that it was these other intervening medical complications that caused his death, not the gunshot wound. It took some studying, and you had to learn some medicine. And I had to drive and talk with some doctors. Now that was a criminal case, but it also required me to study and learn new issues. And I had been practicing criminal law for about 12 years at the time. So, an issue arose which required you to study and learn. I look at a complex civil case no differently. If you don't know the issue, you learn it, and you get help. You go to every resource that you can, whether it's a book or a class or online or another person or a doctor or another lawyer. I mean, you know what I mean? You use whatever resources you can to learn. And it doesn't matter if it's a civil or a criminal case. If you don't know the issue, you learn it.
Right. Now, correct me if I'm wrong, but if, let's say, for instance, an attorney gets elected judge, no members of his prior law firm can appear before him for 2 years. You get elected judge, and you've got prosecutors that you've worked with for the last dozen years, 20 years, whatever, but they get to appear before you the next day.
Well, and obviously, if I was involved directly in the issuance of a warrant or the processing of a case, I would recuse myself from that case. But there are practices and standards in place which dictate the ethical and legal implications of what you're suggesting, and I would follow those to a T.
What makes you different than your 5 opponents?
What makes me different than my 5 opponents is the fact that I have been in the courtroom almost every day of my professional career, practicing in the circuit court of which I'm asking to be elected. I don't think any one of them can say that with as much experience as I have. I've had over 80 felony jury trials. Hundreds and hundreds and hundreds of cases I've handled by way of motions and disposition in the circuit court in Muskegon County. It's that experience that puts me in a position to say I'm different than my opponents.
Okay, I have a few more questions. The first one, we talked a little bit about those that are sentenced and in jail.
Yes.
What about, right now we have about 65% of the population in the jail are awaiting trial. do you think that's a proper, I'm not going into specifics, but just generally, is that a correct amount or should it be lower?
Well, what I think you're getting at is the inmate population that are awaiting trial. And that directly hits on the issue of their bond or bail.
Right.
Because it's their bond or bail that dictates whether they are in jail awaiting trial or not. Again, you have to go back to a series of factors that are laid out in our Michigan court rules that deal with a host of issues. And there's probably 15 different issues that a judge in setting bail is obligated to consider when they set a bail. One of those, and one that I consider to be very weighty, is the seriousness of the offense or the dangerousness of the offender to the community. Now that's pre-trial, and I understand everybody's presumed innocent, but that is a factor that the judge is charged with considering when setting bail. Now bail is generally set in the district court at the time of arraignment. So it can be reviewed and reset by a circuit judge. Absolutely, they have authority to do that. But generally, the standard is set in the district court at the time of arraignment. But those 15 factors all have to be considered.
Talk more about what are the 15 factors?
And I don't have them in front of me, and I don't have them memorized, but I can tell you the seriousness of the offense, the likelihood of conviction. So there is even an evaluation of the strength of the case, and it's often exhibited in a felony case at the time of the preliminary examination, when there's evidence brought before them, or what the officer presents to the arraigning judge at the time of the swearing out of the warrant to present the issue of probable cause. The judge can make a decision and has to make a decision about the likelihood of conviction. How strong is this case? Mental health history, prior criminal history, ties to the community. And there are a number of other factors, but employment history, a number of other factors that a judge has to consider when setting the bail.
So it's not just a one-size-fits-all type of thing?
Oh, absolutely not. And again, I used the term earlier, it's not cookie-cutter bond or bail setting. It's an examination of this case based upon the factors of this case alone, on a case-by-case basis.
Right, exactly.
So when you say, is 65% too high, you'd have to look at each case and say, is that an appropriate bond in this case?
Okay. Well, I didn't think it was just based on bonds, but also how long the trials were, et cetera. And with your experience as a prosecutor, I don't know if you've seen them taking longer than it should.
Every case is different. For example, if you have a complex case that requires a lot of Michigan State Police Crime Laboratory examination or independent examination by a defense expert, DNA examination, it's unlike CSI, it doesn't take 20 minutes to do it. It takes months and months to complete that. And that sometimes prolongs the time of when a trial can commence.
Okay.
So there's a lot of factors in terms of how long somebody sits in jail awaiting trial.
Okay. Do you think I'm jumping around a little bit, I'm sorry, but with the jail, and if it was bigger and we had space available, or should we build in anticipation of selling space to either the state or the federal government?
I think many years ago, there was an opportunity to, and I'm not positive of this, but I think there was an opportunity to collaborate with the federal government and the U.S. Marshal Service and house federal prisoners here. And I really don't know the feasibility of that. And I don't know how much Muskegon County would want to be controlled by the federal government in terms of our operation of a local jail. I don't know how wise that would be. I'd have to explore those options and get some studies and be a little more informed to say whether we would want to do that or not. I wouldn't close the door. I would certainly consider it.
We've had a lot of people actually suggesting that should be one of the things we should do is run the jail as a business.
I would want to know more about it. The jail is unfortunately not a business. It's a mandated service that really is required in any community. So it's I wouldn't want to run it as a business in terms of, yeah, we should do this for profit. We should do it because our community needs to have a solid jail. I look at a solid criminal justice system or a solid justice system in general as one of the pillars of the community. I mean, you need good hospitals, you need good schools, you need good jails, you need a good criminal justice system, you need good courts. That makes a good community. Those are the pillars of the community. The jail's a component of that.
Do we have an adequate public defense system in Muskegon County?
I've worked with it for quite some time, and I believe it is adequate. Yes, I do. I think it is. Yes, to answer your question.
You're aware of a case called Manny's et al. Versus Muskegon County, Genesee County, Calhoun County, brought by the ACLU, where they state, look, for these three counties, the public defender system is not constitutionally adequate.
Well, I'm aware of the case, and I'm aware that it exists, but I'm also aware of many of our public defenders in Muskegon County, and they are good lawyers. I mean, our chief public defender is Chris Wilson. He's one of the best criminal defense lawyers I know.
So you believe that the public defense system is on parity with the prosecution in Muskegon County, and they're both operating on pretty much the same levels of resources and et cetera.
I don't, when you say, are they operating at the same level of resources, I don't know if the budget for the Muskegon County Prosecutor's Office is the same for the public defender system. I don't know that for sure, Mr. Crean, so I would be out of school commenting on budgetary issues, comparing them. I've never been in a position to compare the public defender budget with the prosecutor's office budget. And it might be really comparing apples to oranges a little bit, because the prosecutor's got a staff that involves the victim witness unit, the child support unit, and there's clerical staff and lawyers and investigators that work in that department that really wouldn't have much to do with public defenders. So to include that and to say that those are comparable probably wouldn't be quite accurate. But I know, as with anything, there are different levels of skill, if that's what you're getting at. And in every practice of any endeavor, whether it be doctoring or lawyering or engineering, there are, or architecture, there are some architects that are better than other architects. And that's the human condition.
Child support, somebody doesn't pay it, you gonna send them to prison?
It is a 4-year felony to not pay child support in Michigan, so it is a prisonable offense. Frankly, do I personally believe that someone should be in prison for not paying child support? Probably not, given a very general, broad set of circumstances. No. Given extraordinary circumstances, maybe. Again, this is not cookie cutter justice.
Right.
You can't make a broad general comment about what's right for every case in the world on child support. I'd have to look at each individual case and weigh its equities.
You handled 80 felony cases. Tell us about one of the ones or more than one that you got the most personal satisfaction from.
I've been often asked that question, and I appreciate that, because there's been some very serious felonies in Muskegon County, some of which I've handled. It is not necessarily the one of the biggest public interest that I may have gotten the greatest satisfaction from. To be in a position to help somebody through a very difficult time in their life, it's very satisfying. When they look to you as their champion, as you are arguing my cause, I was victimized, and you are the one that is in front of the jury, and you're making my case for me. That's very satisfying. It doesn't necessarily have to be the biggest media draw, but to have a young person look to me and say, thank you, you did good work for me, I appreciate what you did for me, to me that was the most satisfying. And it involved a very young person that was victimized. I'll just leave it at that.
I have one more question. You kind of talked about it with the other options available, But what is your opinion of using tethers and scrams and other type of electronic devices to monitor either those awaiting trial or that have been convicted rather than putting them into jail?
If appropriate, I would be in favor of using tethers and scrams. A scram is a unit that monitors someone's alcohol consumption, and if the case involved, a serious alcohol problem, I would consider using scram as a viable option. I would consider using tether as a viable option in the appropriate set of circumstances. Again, I go back to how I answered Mr. Crean's question. The more options the sentencing judge has, the more they are able to blend an appropriate sentence. And I would utilize every one of those options, absolutely. And I think that relieves the stress on the jail. When you appropriately use a scram unit or a tether unit, someone's not occupying a jail space, but you've got a control on the person's behavior.
Right.
And it serves its purpose, and you're not utilizing jail space. I think it's a very viable option. Again, in appropriate circumstances.
Anything else you'd like to add that we didn't cover?
No, I appreciate the opportunity to come and speak with you today. I'm excited about this opportunity to serve as the next 14th Circuit Judge. I feel it's important. This is an important race. August 7th is a very important election day. A lot of people look to vote in the primary election. A lot of people they bypass the primary and say, I'll vote in November because that's the general election. They're going to be missing some serious issues in this election cycle if they don't vote in the primary. So August 7th is a very important day, and I would encourage everybody to get out and vote in that primary election.
All right, we appreciate you taking some of your time today and spending it with us, and thank you very much.
Pleasure.